For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Court is in receipt of a proposed consent judgment of divorce. You are Matthew Dandron, is that correct?
Yes.
Mr. Dandron, can you hear the court?
I can. Can you hear me?
Yes, thank you.
Okay.
Is Nicole Dandron present on audio?
Yes, I am here.
The two of you have conferred with Mr. Walker for the court because the court needed to address child support. The court has been informed that the two of you have agreed to reserve child support. Is that correct?
Yes.
Yes.
Okay. So I will put the word, thank you, Mr. Walker, for talking about it. I will simply put the words reserved and I will initial next to the word that I put in there, okay?
Thank you.
Right. It appears everything's in order. Mr. and Mrs. Dandron, can you both please raise your right hand to be sworn, please? Is it true, Mr. Dandron, that you filed a complaint for divorce with this court on or about March 14th, 2024?
Correct.
Is it further true that on the date you filed the complaint that you'd been a resident of the County of Monroe for at least 10 days and stayed in Michigan at least 6 months?
Yes.
Is it further true that you married Nicole Prater, now known as Dandron, on August 17, 2012, and you separated in November of 2020?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes.
Is it true there are 2 children born of the marriage who are still minors, namely Sophia and Emmeline?
Correct.
Were any other children born or adopted during your marriage who are still minors?
No.
And you signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
Yes.
Ms. Dandron, can you please state your name and current mailing address for the record?
Sure. Nicole Marie Dandron.
Thank you. Ms. Dandron, did you hear the testimony this morning of your husband, Matthew?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Okay, I'm going to walk through the terms of this judgment to make sure that everyone's on the same page. You agreed, which is wonderful. The court applauds you. You agreed that you'll share joint legal and joint physical custody of your 2 children.
Yes.
Now, parenting time, you've attached a parenting addendum. Which indicates that you will currently alternate parenting time week on, week off, exchanging on Wednesdays at 5 p.m. Of course, parenting time is always subject to modification if there's an issue. And you've also set forth parenting time schedule for the holidays, which is wonderful. Again, if there's issues and you can't work through that together, and hopefully you can because this is a great start, you can always petition the court for modification of parenting time. Okay, child support, again, the court can indicate that is reserved by agreement. Again, if there's an issue, someone can always petition for child support at a later date. Spousal support, formerly known as alimony, that is not awarded, that's forever barred. You've already divided your personal property, so this judgment provides each party is awarded the personal property occurring in your respective possession, free and clear of any claim on the part of the other. Each will pay debts in their own names. Each will keep their own automobiles, free and clear of any claim on the part of the other. With respect to the real estate, Michigan, that's awarded to the plaintiff, Matthew.
Mm-hmm.
And Mr. Dandron, is title to that property in your name only?
Yes, sir.
Okay, what about the mortgage? Is the mortgage in your name only?
Yes.
All right, that keeps it clean. We just want to make sure, because if not, you need to refinance to remove Nicole's name from that. All right, so that real estate is awarded to Mr. Dandron. Ms. Dandron, you're not receiving any equity for that home. Is that correct?
Correct.
Right. With respect to pension benefits, each will keep their own retirement benefits, whether it's a 401k, IRA, or annuity.
Yes.
Yes.
And Ms. Dandron, you're going to keep the name Dandron, is that correct?
Yes.
Okay. And finally, there's an income tax addendum that the plaintiff, Matthew, is entitled to claim Sophia is independent for tax purposes. Nicole is entitled to claim Emmeline is independent for tax purposes.
Yep.
Yes.
That serves to cover everything. One last issue, and you've been separated for a couple of years. There was a statutory 6-month waiting period, Mr. Standard, any divorce case in which there is minor children. That 6 months begins around the date the divorce complaint was filed. Your divorce complaint was filed in March So 6 months expires in September. But the court has the authority to waive that. The purpose of the waiting period is to make sure there's no chance of reconciliation for the benefit of the children. Mr. Dandron, you've been separated since 2020. You're asking the court waive that waiting period under judgment of divorce today. Is that correct?
Yes.
You believe that to be in the best interest for children to finalize things so you can move forward?
Yes.
Same question to you, Ms. Dandron. Are you asking the court to waive the balance of the waiting period and end the judgment of divorce today?
Yes.
You believe that to be in the best interest for children to finalize things sooner than later?
Yes.
Wonderful. Do either of you have any questions for the court?
No, I do not.
No.
Very well, based upon the testimony that's been, the court will in fact waive the statutory waiting period due to the fact the parties have been separated for 4 years now, and there's no chance of reconciliation. Further, based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties being is thereby dissolved, the judgment shall enter granting a divorce from the bonds of matrimony. Court has signed the judgment. You both know the 2 copy of that. Good luck to both of you. That will conclude this hearing. You can both zoom out and have a good rest of the day.
Thank you. You
Thank
too.
you.
Thanks for your time.
For the record, this matter is before the court this morning for a pretrial conference. The same is being conducted via Zoom. Court is in receipt of what appears to be a judgment of divorce signed by both parties, but not fully completed. Are you Samantha Torres?
I am, yes.
And sir, you are Jose Medina? Mr. Medina, can you sit down somewhere? You're walking around in the yard. Can you sit down and be still for a minute? Can you hear the court? Okay, there. Nature walk.
No. Samantha, is there a way you can text him to turn on his audio?
Yes, 1 second.
Can you
Okay.
see us?
He's froze up.
Right, but can you see us if he turns off, if you turn off the camera?
No, he can't see us, but maybe we
Can he dial, he's able to hear, but I don't know if you guys can hear him. Can he dial that number that's that we got on that letter?
Yes.
Yes.
The
Okay.
646 number?
Yes.
By audio, he dials that phone number, then he adds the Zoom ID number.
Okay.
Mr. Medina, can you hear the court?
He still doesn't have audio and he froze up.
Okay, so yeah, why don't you, he can hang up and why don't you text him, have him call the phone number.
Okay.
Ms. Torres, are you still receiving public assistance?
I'm only receiving Medicaid. I had to reapply for Medicaid for the kids.
Are you currently receiving Medicaid?
Yes.
Okay, the reason is there's a fee waiver of $255. The court will order then your husband to pay that. The taxpayers
Okay.
have to pay that. You appear to be young and able-bodied. And further, your judgment makes reference to only 2 children, but actually you had 4 children, correct?
We have 4 children. Well, I have 4 children. One was from before I met Mr. Mireles, and 2 of those are biologically his, and the other one was born out of wedlock.
Okay, you need to hire a lawyer, ma'am, because it's presumed any children born during the marriage are presumed to be children of Jose Medina.
Okay.
So you need to file a motion to revoke paternity. If one of these children was born during your marriage and Jose is not the biological father, you need to file a motion to revoke paternity. And you need an attorney to do that. So which child was born out of wedlock?
Francesca.
Okay, the
Francesca.
youngest. Okay, what about the other 3?
Penelope and Melanie. Those are biologically Jose's.
Okay, what about you reference also in your divorce complaint that you had a child with Jose Maxiel?
Maxiel, he was before I met Jose.
Okay, was he born before you got married? That's the question. Was he
Yes,
born
he
before you
was-
got married?
Yes.
Okay, so that name should not be referenced on the complaint. It creates a lot of confusion.
Okay.
So Jose is not the biological father of Torres, and Torres was born before you got married, correct?
Correct.
And Francesca was born out of wedlock. So you need DNA testing. You really complicated things by being separated for so many years. So you need to hire a lawyer. If you can't afford, you can't get, the court cannot divorce you until that's been addressed. So that biological father needs to step forward. We need to identify that biological father, and we need DNA testing unless everyone agrees that Jose is not the biological father. So you've complicated things. And you probably need an attorney to help you through that. If you cannot, this is where you reach out to family to help you hire an attorney. And if you can't, then you can contact legal services to assist you.
I did, because so the thing is that, like, the biological father of Francesca, we had signed, to add him, we had to send it to the state of Michigan to add him to the birth certificate.
Well, they can't do that if you're married. So yeah, you need to hire a lawyer to provide the court with all this documentation, ma'am. So hire a lawyer. If you can't afford a lawyer, contact legal services. All right. Is Jose Medina, are you present on audio?
Yes, I listen.
Okay, we'll call the case. For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Ma'am, you are Samantha Torres, is that correct?
Yes.
You never took your husband's last name?
I did not.
And sir, Jose Medina, you're present on audio, is that correct?
Yes.
Okay, Ms. Torres, Mr. Medina has advised the court that that the minor child, Francesca, is it Francesca?
Francesca, yes.
Francesca, that you are not the biological father of that child. Is that correct, Mr. Medina?
I'm sorry, I cannot understand very well. Can you put the translator?
We don't know. You need to let the court know in advance. I just don't have translators in my office. You need to let the court know in advance. You have a family member that can sit with you.
But I don't have nobody.
All right, the court cannot, Ms. Torres, perhaps you can explain to Mr. Medina afterwards that the court cannot grant a divorce without us determining the paternity of this child, this third child.
Okay.
Ms. Torres, your address is still correct?
That's correct. Yes.
Okay, Mr. Medina, Mr. Medina, do you still reside at 3?
No, I switched my address.
Okay, what is your new address? Or perhaps you can make that inquiry, Ms. Torres, and I can write down his new address for mailing purposes.
The address is 29.
All right, the court's going to take some brief testimony from Ms. Torres to establish the minor children. There's been a breakdown, no chance for reconciliation. And Ms. Torres, please do not get pregnant while this matter is pending, because that just further complicates it more. Okay?
Okay.
Let's get divorced first.
Okay.
All right, and perhaps your attorney can line up an interpreter if necessary, or Mr. Medina can bring a family member into a system interpreting.
Okay.
All right, Ms. Torres and Mr. Medina, can you both raise your right hand to be sworn, please? Yes. Ms. Torres?
Oh, I swear.
Yeah, okay. Mr. Medina?
Yes.
Thank you. All right, Ms. Torres, please state your name and current mailing address for the record.
Samantha Chavaria Torres.
Thank you. Is it true, ma'am, that you filed a complaint for divorce with this court on about March 6th, 2024? Yes. Is it further true that on the date you filed the complaint, you had lived in the county of Monroe at least 10 days and stayed in Michigan at least 6 months?
Yes.
Is it further true that you married Jose Medina on July 13th, 2017, and you separated in March of 2019?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed? There's no reasonable chance of reconciliation?
Yes.
Is it true that there were 3 children born during your marriage? 3 children born during your marriage, namely Melanie, Penelope, and Francesca?
Yes.
And only Melanie and Penelope with the biological children of your husband, Jose. Is that correct?
Yes.
Are you currently pregnant?
No.
Right, the court's going to amend your complaint and strike the name Maxiel because Maxiel was born prior to the marriage, has nothing to do with Mr. Medina. And minor child Francesca, born out of wedlock. Have you already divided your personal property?
We don't have none. No.
Okay. And spousal support is not appropriate, being a 2-year marriage. You've agreed upon joint physical custody of Penelope and Milani. Jose will have parenting time on his days off.
Mm-hmm.
Does Mr. Medina pay any child support right now?
He is not. According to the child support office, at downtown Monroe, they told me that because he doesn't have a social, I can't receive it.
Are there any joint debts?
No.
Is there any real estate or retirement benefits?
No.
Right. Mr. Medina, can you state your name, please?
Jose Noé Mireles Medina.
Did you hear the testimony of your wife, Samantha, this morning?
I'm sorry.
Okay, Ms. Torres, perhaps you can ask him, did he understand your testimony this morning?
¿Tú entendiste lo que yo dije?
No.
Dije que Maxiel Chavarría Torres no es tu hijo y que Francesca no es tu hija y nomás Penelope y Milani es tu hija. Y no tenemos nada que dividir, no tenemos real estate, no tenemos deudas, no tenemos nada de eso. ¿Entendiste eso?
Oh, sí, lo entendí.
Dile a él que lo entendiste.
Yes, I understand.
Okay. All right, Mr. Medina, the court cannot grant a divorce until we establish paternity and we revoke paternity of the minor child, Francesca. So Ms. Torres is going to hire an attorney. You need to do that, ma'am, if you want to get divorced. And the court can't sit on this for 6 months. Okay?
Correct.
So what the court's going to do, the court's going to set another pretrial conference. You think you can have an attorney on board within a month?
Yes.
Okay. And if you cannot afford an attorney, contact Legal Services of Southeastern Michigan. They can provide you with, do we have their phone number? Let's give her that phone number.
I had contacted them previously. Yes, it's okay.
Okay. Well, you need their help because you need to revoke paternity. You need to file a motion and we need to determine all that. Is the biological father of Francesca, is he still here in the United States?
He is, yes.
Okay, will he appear and cooperate and appear in court and say that he's the biological father of that child?
Yes.
Okay, if so, that might eliminate the need for DNA testing because that's an expense and that will also be a delay.
I understand.
If you and the biological father and Jose all testify that third party is the biological father, then that will be much cleaner. So you'll contact Legal Services. When you first contacted them, why did they assist you?
They did not assist me because the attorney I had contacted or they had assigned to me, we were going back and forth. We never had either she was busy or I was busy. It was just a back and forth thing. And I did receive advice from an attorney when I had called, and he had said to get a divorce first and then do.
Right. You can't get a divorce though until we address the revocation of paternity.
Okay.
Right. So
I understand.
So the court will give you a date for another pretrial conference. The court would first of all note that based upon the testimony that's been presented by the plaintiff, as well as complaint filed in this matter, the court finds that jurisdiction has been established and there's been a breakdown of the marriage relationship, no chance of reconciliation. The court will reserve all outstanding issues until we address. The only issue appears to be the revocation of paternity. And we'll give you a date for another pretrial conference. Sarah, do you have a date? Hold on. All right, the court will schedule this for a continued pretrial conference on Friday, August 16th at 11 a.m. So make note that it'll be via Zoom. The court will mail out notice to Ms. Torres as well as Mr. Medina. Do you have any questions, Ms. Torres?
I do not. August 15 at 11 a.m., correct?
The 16th, Friday,
The
August 16, 1/6, 11
Okay.
a.m. via Zoom. We'll mail you notice at 162. Reach out to legal services or the attorney today or Monday. Let's move on this matter, okay?
Okay.
And
Yes.
Mr. Medina, do you have any questions for the court?
Oh, no question.
Okay, the court will mail you out notice. Now we'll conclude this matter. You can both zoom out.
So we have the interpreter here, so that he's.
Okay, well, I have a PPO and also Jill waiting. Should we, can we do this in the next 5 minutes, Mr. Kazmarek?
I highly doubt it with an interpreter
Okay.
here. Trying to,
Right, I'm just gonna put everyone on hold right now so I can take care of these matters relatively
that's
quick.
fine.
I'll be right back with you, so everyone can please just hold on here.
Fine.
Jim Blair's just calling. He's not talking to the guy, but he's gonna zoom in, put on the breaker with the guy.
Yes.
Okay. Court is in receipt of a proposed consent judgment of divorce, which both of you have completed and approved. However, you did not address the issue of child support, so the two of you have met with Mr. Walker from the front of the court this morning, and Mr. Walker is providing the court with a recommendation. Are you both agreeable with that recommendation?
Yes.
Walker has provided a uniform child support order, which he has prepared. Thank you, Mr. Walker. That the recommendation is effective September 1st, 2024. So it's not going to begin until September. Then Ms. Cadorin will pay to Ms. Cadorin the sum of $1,038. Uninsured medical expenses will be shared as follows: 44% paid by mother, 56% paid by father. For child support, it's always subject to modification as circumstances change, incomes increase or decrease. Children get older. There's always either party can always petition the court for a modification of child support. Is this a recommendation agreeable with you, Ms. Cadorin?
Yes, it is.
Mr. Cadorin, is this recommendation agreeable with you as well?
Sure.
Okay, all right, so the court will sign that. I'll print it out and I'll attach that to the judge. Mr. Walker, thank you for your assistance this morning.
You're welcome, Your Honor.
Right, Mr. Cadorin, can you both please raise your right hand to be sworn, please? Thank you. Is it true, ma'am, that you filed the complaint for divorce with this court on about March 25th, 2024?
Yes.
Is it further true that on the date you filed the complaint that you'd lived in the county of Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes.
Further true that you married to Benjamin Cadorin on April 11th, 2014?
Yes.
When did you separate? Approximately what month? What year?
March 2024.
March of 2024. Is it true, Ms. Cadorin, there's been a breakdown of your marriage relationship to the extent that the opposite matrimony has been destroyed? There's no reasonable chance of reconciliation.
Yes.
Is it true that there were 2 children born of the marriage who are minors, namely Jackson and Audrey?
Yes.
Were there any other children born or adopted during the marriage who are still minors?
No.
Are you currently pregnant?
No.
And you've signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Correct.
All right. So, Mr. Cadorin, could you please state your name and mailing address for the record?
Yep, Benjamin Allen Cadorin.
I'm sorry, Mr. Cadorin, you're confusing the court. Where do you want this judgment of divorce mailed to you at? What address?
I wanted to use my my current legal address.
Okay. If in fact that's where the front of the court will use that for all purposes, if you change your mailing address, you need to inform the front of the court in writing. Okay.
Okay,
2092.
I'm sorry, I'm having trouble hearing you.
Okay, Mr. Cadorin, we're going to use the mailing address at agreeable.
Yes.
Okay, Mr. Cadorin, did you hear the testimony of your wife, Lauren, this morning?
Can you repeat that? I'm sorry, you're breaking up.
Okay, you must have weak internet. Did you hear the testimony of your wife, Lauren, this morning?
Did I talk to her?
Okay, I'm going to give you a phone number to call in because you obviously weak internet. So I'm going to give you a phone number. You got a piece of paper and pen. You call in and appear by audio. Your signal is way too weak. Well, you're on the phone. Did you hear the testimony of your wife this morning, Mr. Cadorin?
Yes. I just heard
Okay.
it. Now,
Was her testimony true and accurate?
yes, it was true and accurate.
Did you sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Okay, I'm going to walk through the terms of this judgment with both of you. You've agreed that you'll share joint legal and joint physical custody of your two children.
Yes.
You've agreed that the two of you will agree upon parenting time. So reasonable, liberal, whatever you agree upon. If you cannot agree, either one of you can file a petition with the court, and the court would establish a specific parenting time schedule. Child support will be in the amount reference recommended by Mr. Walker, $1,038, and that will commence on September 1st.
Yeah.
Of 2024. Spousal support is not awarded. That's forever barred. You've already divided your personal property, so each will keep personal property occurring in your respective possession, free and clear of any claim on the part of the other. There are no joint debts, so each will pay any debts in their own name. Each will keep their own automobile and pay any debt thereon. And with respect to the real estate, known as 209, to both of you will share equally the mortgage and the other expenses. And you've agreed to list that home for sale. Is that correct?
Correct. It is currently for sale.
Okay. So you will share equally the net sale proceeds.
Yes.
And finally, you've attached a income tax addendum that the plaintiff mother is awarded the right to claim the two children as dependent for tax purposes. And that is it.
Yeah.
Miss Cadorin, do you have any questions for the court?
The only thing that I believe should be addressed there is that I do plan to change my name.
Yes, I do see that. I apologize for not mentioning that. Yes, judgment does provide that your name shall be modified and changed to Lauren Joe Berger. When you get a copy of the judgment, you need to take a copy to Secretary of State and Social Security to facilitate that change, okay?
Okay.
Do you have any other questions, ma'am?
I do not.
Mr. Cadorin, do you have any questions for the court?
No, I do not.
And I guess finally, yes, with respect to retirement benefits, you've agreed to each keep your own, free and clear of any claim on the part of the other, whether it's a pension, a 401k, or annuity. Agreeable?
Yes.
Yeah.
All right. Based upon the testimony, it's been, it's one last question. There's a statutory 6-month waiting period in any divorce case in which there's a minor child, just to make sure there's no chance of reconciliation. And the 6 months begins to run the date the divorce complaint was filed, which was March 25. So 6 months expires in September, about 2 months from now. But this court has the authority to waive that and enter the judgment of divorce today. The court would do so if you both agree. Ms. Cadorin, are you asking the court to waive the balance of its waiting period and enter the judgment of divorce today?
Sure.
Do you believe it to be in the best interest of your children to finalize things sooner than later?
Yes.
Same question for you, Mr. Cadorin. Are you asking the court to waive the 6-month waiting period and enter the judgment of divorce today?
Yes.
Do you believe that to be in the best interest of your children to finalize things sooner than later so you can move forward?
Yes.
Very well. The court will do so. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter, granting a divorce from bonds of matrimony. The court has signed the judgment. You'll both be mailed a copy. That will conclude this hearing. You can both zoom out, and I applaud you for each agreement that you can co-parent your two children. Communication is the key. There's enough challenges in life, so make it good for each other and the children. All right, that will conclude, sir. You can both zoom out. Have a good rest of the day.
Thank you. Can I ask one more question?
Go ahead.
So what is the final date of the divorce?
The court is signing the judgment this morning, so you're divorced.
Okay.
All right, good luck.
Can you repeat that or reverberate? I didn't hear what
The
you
court
said.
is signing the judgment of divorce this morning. You'll both be mailed a copy, and you'll both get a copy next week, and that will conclude this proceeding.
Okay. Perfect.
Okay. Thank you.
Thank you.
All right, good luck to both of you.
Yes.
Right, yeah, ma'am, you're Crystal Shiffert, is that correct? Can you unmute yourself?
Correct. Yes. Hello.
That's better. All right, then, sir, you're Michael Shiffert?
Yes, sir.
All right, the court is in receipt of a proposed judgments. It did not address child support, but the court's informed that the two of you have agreed to reserve child support. Is that correct?
Correct.
And of course, that is always subject, either one of you can always petition the court for a child support order, but until then it's reserved. I'm going to write that in the judgment, the word reserved, because we need to address that. And then I'll just put my initials next to the word reserved. Is that agreeable with both of you?
Yes, sir.
Earl, can you both please raise your right hand to be sworn, please? Thank you. And Ms. Shiffert, is it true that you filed a complaint for divorce with this court on about March 19th, 2024?
Correct.
Is it further true that on the date you filed the complaint that you've been a resident of the county of Monroe at least 10 days, the state of Michigan at least 6 months?
Correct.
Is it further true that you married Michael Shiffert on October 29th, 2005, and you separated in January of 2020?
Correct.
Still living together, but you've not been living together as husband and wife for a number of years. Is that correct?
That is correct.
Is it true that there were 2 children born of your marriage who are still minors, namely Kate and Garrett?
Correct.
Were there any other children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
Okay. And you signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Correct.
All right. And Mr. Shiffert, can you please just state your name and mailing address for the record?
Michael Lee Shiffert, 182.
Thank you. Mr. Shiffert, did you hear the testimony of your wife, Crystal, this morning?
Yes, I have.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I have.
Okay. There's a statutory waiting period of 6 months in a divorce case in which there are minor children, just to make sure no chance of reconciliation with benefit of the children. The 6-month waiting period begins to run on the date the divorce complaint was filed. Ms. Shiffert filed this complaint on March 19th. So 6 months expires September 19th. This court, however, has the authority to waive that waiting period and end the judgment of divorce today. The court would do so if you both agree. And you believe that being the best interest for children to simply finalize things sooner than later so you can move forward. Ms. Shiffert, are you asking the court to waive that balance, that waiting period?
Yes, please.
If you believe it's in your children's best interest to finalize things today, so you can move forward.
Yes.
Same question to you, Mr. Shiffert. Are you also asking the court to waive the statutory waiting period, the balance of it, and enter the judgment of divorce today?
Yes, please.
All right, I'm going to walk through the terms of this with both of you. And I applaud you for reaching your own agreement. You can co-parent your children. You've agreed to joint physical custody. You have a specific parenting time schedule written in the judgment. Obviously, communication is the key. If you need to modify this, hopefully the two of you can agree. I applaud you. It's wonderful. Your children will thrive because you're on the same page. There may be challenges in the future, but they can all be addressed through effective communication. If in fact you need help, someone can always petition the court to modify a parenting time schedule. But they should spend as much time with each parent as possible. Child support, again, is reserved. Spousal support or alimony, that is not awarded. That's forever barred. Personal property is divided according to the attached personal property addendum. You've attached an addendum. Pursuant to which the plaintiff, Crystal, is awarded the family pets. Loki, Freddie, and JoJo. Defendant Michael is awarded Zoe and the fish. It also says any other possession, any other property in his possession or her possession is awarded that property, but you're still living together. So
Yes.
You both agree that will not be an issue. Each know what each is going to take when you separate.
Correct.
Who owns the home? Are you renting?
We currently own it together, but in the judgment, we hash that out.
Yes. Okay. I will. I do see that. We'll address that in one moment. So you've agreed upon personal property, vehicles. They're divided according to the vehicle addendum, which is attached. Plaintiff Crystal is awarded the 2012 Scion, and Michael is awarded the Ford Explorer. Each will pay any debt on their respective vehicles, free and clear any claim on the part of the other. Each is awarded their own retirement benefits, whether it's a 401k, pension, or annuity. With respect to the real estate known as 2176 Smith Road, that is awarded to the plaintiff Crystal. She should pay any mortgage or debt thereon. She shall refinance to the home to remove defendant's name from the mortgage, and Michael will sign a quick claim deed. The only thing we need to address is that time frame. There's no time frame. Do you want to say 6 months, 12 months? I'm just trying to minimize and avoid issues down the line.
Yeah, to refinance that, I think 6 months is ideal.
6 months from today's date is agreeable, Mr. Shiffert?
I
Yeah.
agree.
Okay, and obviously it's so So, but in the meantime, you're going to pay the mortgage payments, correct, Ms. Shiffert?
Correct. Yep.
All right, the court's going to write in here, and I'm going to put within 6 months, and I'm going to put my initials next to that, since you're both agreeable. Finally, there's a provision in the judgment that the defendant shall be awarded $10,000 for use of a down payment on a new home. So when you refinance the home, Ms. Shiffert, you're going to borrow an additional $10,000 to pay to Mr. Shiffert. Is that correct?
Correct.
Okay. And it's further noted that the defendant will reside as roommate in plaintiff's home until they're able to purchase a home, but no later than 2 years. So Mr. Shiffert can live there rent-free for 2 years, correct?
No, I'm still going to be paying basically like room and board.
Okay.
I'll be adding a little bit for the fact that I am still living here at the time. So we've kind of agreed on a minor amount of payment.
Okay, but that's not spelled out in here, but that's, you both can work through that together,
Yes.
right? Right, do you have any questions, Ms. Crystal?
I do not.
Mr. Michael, do you have any questions for the court?
No, sir.
Well, based upon the court appreciates both of you putting together this consent judgment. It's wonderful you can agree upon these items. The court will waive the balance of a 6-month statutory waiting period based upon the agreement of both parties. Further, the court would note that based upon the testimony that's been presented this morning, as well as complaint filed in this case, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. Court will sign the judgment. You both will mail the copy. Good luck to both of you. And that will conclude this hearing. You can both zoom out.
Yes,
Thank
sir.
you, sir.
You're welcome. The court for a pretrial conference, the same as being conducted via Zoom. Is Patrick Bane present on audio?
Yes, I am.
Good morning. Is Kelly Bane present on audio?
Yes, I am, sir.
Good morning. Court is in receipt of a proposed consent judgment, which both of you appear to have approved. Can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank
Yes,
you. We will start with you, Patrick McBain. Since you're the plaintiff, can you please state your name and current mailing address for the record?
Patrick Michael Bane, 2510.
Mr. Bane, is it true that you filed the complaint for divorce with this court on or about April 3rd, 2024?
Yes, sir.
Is it further true that you had resided in the county of Monroe for at least 10 days, state of Michigan, at least 6 months prior to the date you filed that complaint?
Yes, sir.
Is it true that you married Kelly Allen, now known as Bane, on October 9th, 2019? You separated in February of 2024.
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes, sir.
Were there any children born or adopted during your marriage who are still minors?
No.
Did you, in fact, sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Ms. Kelly Bane, can you please state your name and mailing address for the record?
Kelly Sue Bane.
Ms. Kelly, did you hear the testimony this morning of your husband, Patrick?
I'm sorry, sir. I couldn't hear you. What?
Did you hear the testimony of your husband, Patrick, this morning?
I did. Yes, sir.
Was his testimony true and accurate to the best of your knowledge?
Yes, sir.
Are you currently pregnant?
No.
Did you sign your name to this proposed judgment proving the terms and conditions contained therein?
Yes.
Okay, I'm going to walk through the terms of judgment with both of you. You've agreed that spousal support is not awarded, it's forever barred. You've already divided your personal property, so each will keep the personal property currently in your respective possession, free and clear of any claim on the part of the other.
Yes.
With respect to debts, it says debts are divided according to the attached debt addendum. And you've got both signed agreement where the federal income tax debt to be divided in the amount of $6,413 between Patrick and Kelly. That was prepared by Hopkins Tax Service on April 11, 2024, and has been submitted to the court previously. I'm not sure what you mean by the court previously. To what court, Mr. and Mrs. Bane?
When I did the answer to complaint, I had submitted the tax document, the amount owed.
Okay, but the two of you have agreed to each going to share what equally? It's not real clear, is it? You just said it's going to be divided. You're going to share equally that $6,413 debt?
Yes, sir.
Equally.
I have spoken with the IRS and they're adding penalties and interest. So I have an appointment on the 16th of July and I'm pretty sure we can come to an agreement. I have to go see a tax administrator.
Okay. Is it agreeable? I'm trying to minimize issues because it's not real clear in your judgment. Can I put in the word that debt will be divided equally or shared equally?
Yes, sir. That's fine.
Okay. And I will add that language. I'm going to put my initials next to that. So you should probably both meet with the IRS because that will benefit both of you if you get it reduced.
Absolutely.
And it's already paid off unless you're paying interest.
We'll try to work that out amongst us. Thank you.
Okay, I've added that, said that should be shared equally, and I'm putting my initials next to that. So there's no question. Okay, that's only a joint debt, is that correct?
Yes.
Yes.
Okay, each, with respect to motor vehicles, each will keep their own automobiles free and clear of any claimant part of the other. There's no real estate to be divided, and there are no pensions or retirement plans to be divided, is that correct?
Yeah.
Correct.
Okay, you've attached a, there's also a state of Michigan debt to be divided, $1,811. That will also be shared equally, correct?
Yes, sir.
Yes.
Okay, I'll clarify that. Vehicles. Each will keep their own vehicle free and clear of any claimant part of the other. Is that correct?
Yes, sir.
Okay, and that appears to cover everything. The one last issue is there's a fee waiver in this matter. When Mr. Bane, you filed this matter, were you on public assistance?
Yes, but I agreed to pay for it.
Okay, because the taxpayer should have to pay this. There's a filing fee of $175. I'm going to write in the judgment that you've agreed to pay that. I need a time frame by which you can pay that. Can you pay that by the end of July?
No, sir, I wouldn't be able to. I was hoping I could make 3 installments.
No, the clerk's office will not accept installments. It's got to be paid in one lump sum. So you need to put that money aside, or maybe borrow the money. I don't know if Miss Bane wants to help you with that, the $175. But the clerk's office will not take installment payments. So you got to put that aside yourself and come in and make it in one lump sum.
Sir,
Okay,
my client is in the hospital, so I'm not even working this week at all. So I don't think that I'll have the money to do that immediately in July.
Okay.
If you could stretch it out till August, we can probably come up with it together in August.
Okay, so if Mr. Bane, the clerk office will not take partial from one or the other. So Miss Bane, if you want to help him out, that's between the two of you. Mr. Bane, if I put in the judgment, you'll pay that by August 30th. Will that work for you?
Yes.
Okay, I'm gonna write this in judgment, Mr. Bane. Do not ignore it. If you can't pay by then, you call the court and I'll give you additional time. If you blow it off, that's when bench warrants issue, and we don't want bench warrants issue for your arrest.
That's not gonna happen, Your Honor.
Okay, so it's you pay the county clerk, same place where you filed your divorce complaint, but right in the judgment, you'll pay the $175 to county clerk on or before August 30th. It's the last Friday in August, and hopefully Miss Bane can assist you in that and give you part of that, but you pay in one lump sum. Okay. Any questions, Mr. Bane?
No, sir.
All right. Miss Bane, you're going to keep the name Bane, is that correct? You don't want your former name restored?
Yes, sir. I'm going to keep it. I just changed all my stuff recently in the last few years.
Okay. All right. Miss Bane, do you have any questions for the court?
I do not, sir.
Okay, again, the court's going to add the language of the judgment. I'll put in my initials next. It's Bane that you shall pay the $175 filing fee to Monroe County Clerk on or before August 30th, 2024. Okay.
Yes, sir.
Thank you.
Very well, based upon the testimony that's been presented this morning, as well as the complaint filed this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it's ordered by this court that the marriage between the parties be and is hereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. The court has signed the judgment. You're both divorced now. A copy will be mailed out to each of you. And now we'll conclude this hearing. You can both zoom out. Have
Thank
the rest of the day.
Thank you, sir.
Thank you. Thank you,
You're
sir.
welcome. You're welcome. The court for a continued pre-trial
Right.
conference, as well as the plaintiff's motion for entry of a proposed default judgment of divorce. Is Crystal Vincent present on audio?
Yes, sir.
Morning. Is Kaz Vincent present on audio? It appears that he is not. This matter was scheduled for a continued pre-trial conference, as well as notice for entry of a default judgment at 11 a.m. this morning. It's now 10 minutes after 11. Mr. Vincent has not appeared. He's not contacted the court. Ms. Crystal, have you had any contact with your husband in the last 2 weeks?
I have. I informed him that the court was July 5th. He said he would be here, but then he went to Sacred Heart and signed himself into a rehab the other day. So I haven't had any contact with him since. I contacted his counselor this morning and he said he would let him know. So I don't know.
Okay. And if he were here, would he agree there's really nothing at issue?
I'm sorry?
If he were here, would he agree that there is nothing in dispute or nothing at issue?
Agreed. He would agree. There's nothing to dispute.
Okay, Ms. Vincent, are you still receiving public assistance?
Yes, sir.
Okay. There's a filing fee and the taxpayer should have to pay this filing fee. What kind of public assistance do you receive?
I get Social Security, SSDI, and I also receive Medicaid and food stamps through DHS.
Okay. Mr. Vincent is also unemployed?
As far as I know, he is unemployed. And I don't think he receives Medicaid through the state. That's all.
All right. The court will accordingly waive the filing fee that was previously suspended by the clerk. All right, Ms. Vincent, can you raise your right hand to be sworn, please? Do you solemnly swear affirm that the testimony you're about to give us matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name and current mailing address for the record.
Crystal Vincent,
Thank you. Ms.
610.
Vincent has a truly filed complaint for divorce with this court on March 4th, 2024.
Yes, I filed.
Is it further true that you were a resident of the County of Monroe for at least 10 days, state of Michigan, at least 6 months on the date you filed that complaint?
Yes.
Married to Kaz Vincent on March 17th, 2022, and you separated in August of 2023.
Correct.
True, there's been a breakdown of your marriage relationship to the extent that the objects of matrimony are destroyed. There's no reasonable chance of reconciliation.
Absolutely not.
Were there any children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Okay, the judgment of divorce that you have approved, submitted for default entry in case spousal support is not awarded, it's forever barred. Each of you will keep the personal property current in your possession, free and clear of any claim on the part of the other. There are no joint debts, so each of any debts in their own name. Each keep their own automobile. There's no real estate to be divided, no pensions to be divided. And you're asking for restoration for the name of Crystal Wickings, is that correct?
That's correct.
Do you have any questions for the court?
I'm sorry, I didn't hear you.
Do you have any questions for the court?
Am I able to change my name today by chance?
Yes, there in the judgment divorce, I put that your former name is restored of Crystal Wickings.
Okay, great. Thank you.
When you get a copy of this judgment, you need to take a copy to the Secretary of State and Social Security to facilitate that name change.
Okay, I have appointments for that today. Is there any way I could pick up that paperwork today?
You have to come down to the county courthouse to get it. Go to the county clerk's office,
great.
county clerk's office, second floor. Very well,
Thank
based
you
upon
so
the
much.
testimony that's been presented this morning, and it's the court notes almost 11:15. Again, Mr. Vincent has not appeared. He's not contacted the court in any form or fashion. Entry of a judgment by default is appropriate. Again, based upon the testimony that's been presented this morning, as well as the complaint filed in this matter, the court again finds jurisdiction has been established and that there's been a breakdown of the marriage, no chance of reconciliation. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved and judgment shall enter granting a divorce from bonds of matrimony. All right, the court signed the judgment. Good luck to you, Ms. Vincent. If you don't come down today, a copy mailed to you at 6:10.
I will be on my way. Thank you very much.
Thank you. All right, have a good day. Thank you.
You too. Woo!
Hey, you can hang up.
It's not a matter of Anthony Benton versus.
Are you Brittany Rowe?
I am.
Right, for the record, Miss Brittany Rowe is appearing this morning via Zoom from the Monroe County Jail, having been arrested on a bench warrant in the last 24 hours. Also present, Monroe County front of the court, Mary Patrice Patrick. Ms. Rowe, can you please state your mailing address for the record?
My address, 109.
Thank you. Ms. Patrick, can you provide with court some information regarding Ms. Rowe?
Yes, Your Honor, thank you. Ms. Rowe currently has a warrant for her arrest. We're asking for that to be rescinded and canceled. That's been out there since February of 2024. The account is charging $194 per month. There's an arrears of $1,028.70. Last voluntary payment was $81 that was made on April of 2023 from an employer. At this time, the front of the court is going to ask for a finding of contempt. I believe that's going to be a first finding, Your Honor, and we would ask for 20 days or $500.
All right, Ms. Rowe, are you currently employed?
I am.
Okay, where are you employed?
Jersey Mike's.
I'm sorry, Mike's?
Jersey Mike's. It's a sub shop.
Jersey Mike's, okay. You
Yes.
work full-time?
I do not.
Okay. Again, you heard that it's been alleged you've not made a payment since April of 2023, over a year ago.
Yeah. Yeah.
Appeared to be able-bodied and young. And this is adding up $194 a month. So you're sitting on your hands. If you can't afford that, you need to file a motion to reduce your support.
Yeah, I do need to file a motion. I've been meaning to because my daughter doesn't even live with her dad, so she hasn't been there in 2 years. And I've still been, this has been racking up for nothing.
Are you being held in jail on any criminal charges this morning?
I don't think so. Just this.
All right. Do you understand you're being charged morning with civil contempt of court for failure to pay child support? Upon conviction, you could be ordered to serve up to 45 days. And Ms. Patrick is recommending some immediate jail. Because there's possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all that?
I do.
Are you asking for a court-appointed attorney?
Yes.
Okay. Let me ask you a few questions. First of all, I want you to give me a cell number in the event you are able to post bond over the weekend. The attorney can reach you by your cell phone.
Can somebody reach me by my cell phone?
Do you have a cell number you can provide the court? Because the court
Yes, I do. I'm sorry.
attorney, and if you post a bond over the weekend, at least the attorney can reach you by phone. So give me a cell number, please.
It's 313.
Okay, and your sole income right now is Jersey Mike's.
Yes.
You get paid every week or every 2 weeks?
Every 2 weeks.
Approximate take home every 2 weeks.
It's different every 2 weeks, probably about 500.
Okay, how long have you worked for Jersey Mike's?
Like over a year, a little over a year.
Do you have any other income?
No.
You own any property of any value? For example, do you have any bank accounts?
No.
Automobile?
No.
How do you get to and from work?
The bus.
Okay.
Or I get rides from people.
Okay.
I don't have a license right now, so.
Okay, the court's going to set this. We can't get a corporate attorney on board immediately, so the court's going to set this for hearing then on Monday, July 8th, 11:15. The court will set a bond, Ms. Rowe. So if you post this bond, the court has no objection if you want to appear via Zoom. We'll provide the court Zoom ID number. If not, from home or for work. You think you still have the job if you can bond out over the weekend?
Yeah.
Okay. Well, of course, when you get out of jail, you need to go to the front of the court. Of course, they're not open on Saturday, Sundays. You need to file a motion to reduce your support. Be proactive. If you can't afford $200 a month, you need to file a motion to reduce your support.
Okay. I just procrastinate sometimes.
Who do you live with, Miss Rowe? Do you live with family that can post a bond on your behalf? This is where you reach out to family and friends.
I mean, I don't think my mom can. I live with my mom, but I might have somebody that can.
Okay, can you post $500?
I don't know if I could do that much.
Well, how much can
I
you
have
post?
money, but I don't have that much. Maybe
When did you
two.
last get paid?
I just got paid, but I don't have it in cash. Everything's on my card and I have all my property.
Okay, well, when you get out, so you have no cash, but obviously you can pay someone back. So you got $500 on
Yeah.
that card, is that correct?
I should, between my
Okay.
savings and,
So can you reach out to someone and they can post $500 bond on your behalf and then you can pay them back? Will that work?
I
I'd
hope.
like to see you get out. Ms. Patrick,
Me
any
too.
objection to a $500 cash bond?
I have no objection to that, Your Honor.
All right. Right, Ms. Rowe, the court's going to set bond amount of $500.
thank you.
Bench warrants, you not made payments in over a year. So if you can post that bond this afternoon, you'll be home for dinner tonight. And
Yeah.
that'll apply 100% toward your arrearages. There's no fines or court costs or corporate return fees. It's going to apply 100% to your arrearages. So make some phone calls, get the $500 together. You can pay them back when you get out. And then you can appear via Zoom, or you can appear in person if
On
you want on Monday. But you're going to appear on Monday, July 8th, 11:15. We'll put in this order a Zoom ID number for the court. And your
Okay.
attorney will reach you by your cell number if you posted bond. If you can't post bond, the attorney will probably talk to you Monday morning via Zoom from the county jail.
Okay.
So what the court suggests between if you post, you make calls, get this bond posted so you can get out, get back to work. And then on Monday, come down to the front of the court and fill out you can ask your caseworker for a motion packet. You can file a motion to reduce your support if you can't afford this $194 a month. And then you compare personally, it might be easier.
Yeah. See, it's not about not being able to afford it. It's a whole completely different thing that my daughter doesn't even live with her dad. So I don't think it's fair for me to have to pay him anything because he doesn't take care of her. She's either with me or his mother.
Hold on. It may not be going to him. It may be being redirected, who's ever got possession of your child.
It's
so
not.
This is not a matter of fairness. If in fact you can't afford that amount, then you file motion to reduce support. Now, if in fact your daughter's with someone else, maybe it's been redirected to that third party. I don't know.
I need it to get redirected. That's what I need to put in for. That's what I need to do because it does need to go to his mother.
Okay, well, that's between Mr. Vinton and his mother, I suppose.
Yeah.
Ms. Patrick, anything from your standpoint?
No, Your Honor, only in that the front of the court was aware of that and she was instructed to file a motion and she failed to do that. So we were aware of the situation, but she has taken no action so that the front of the court can modify it. So, but nothing further, Your Honor.
All right, Ms. Rowe, you'll hear from a court-appointed attorney. We'll see you on Monday at 11:15, and again, hopefully you can post that $500 cash bond so it can be released this afternoon. Okay.
Okay. Thank you so much.
Okay, you can step out unless you have any other questions.
Nope.
All right, thank you.
Thank you, Your Honor.
Thank you.